Hello everyone, my name is Paz Gallardo and I'm a lawyer of SOURCE International Organization. SOURCE is an NGO who work with communities affected by mining activities with the aim to provide evidence of pollution and human rights abuses. In this lecture, I will talk to you about integrating gender into environmental and social impact assessment and other legal mechanisms and processes. In lesson 1, you learned about the particular impacts of gender-based violence on women's livelihoods and how to do a woman-tailored human rights impact assessment. This lecture will build on this information. We will go over the steps of the environmental and social impact assessment in more detail. I recommend that you go through lesson 1 before watching this video. So let's start. The purpose of an environmental and social impact assessment is to assess and predict potential adverse social and environmental impacts from mining, and to develop suitable prevention and mitigation measures. Conducting a gender analysis and integrating gender into impact assessment can help give voice to women's perspective, needs, and interests. Furthermore, it can help to address power imbalances between companies and communities and within communities. Factors considered in inclusion of a gender analysis vary a lot from region to region, place to place, and country to country. So the assessment should be tailored and adapted to the context before and during the process. The first stage of the process is a screening of project feasibility. During this stage, you have to conduct gender analysis based on data collected through reconnaissance surveys in the project affected area to understand gender issues in terms of how gender roles and relations are structured, how they function, and the gender division of labor and responsibilities, how livelihoods of women and girls are structured in the specific context, how is the income distribution between men and women, which are the existing health issues and the gender prevalence, and the dependence of natural resources and the gender difference between the dependency of men and women to these resources. Gathering gender information at this stage will help to frame gender-responsive terms of reference for the assessment project during the scoping stage. In order to do so, you have to review literature, meet local authorities, organize public meetings and consultation with communities, and meet women stakeholders like women associations, unions, or any local or grassroots women groups. During the next stage, the scoping the assessment, you have to use data collected in the previous step in order to explore questions like issues in need of immediate redressal, like access to health, sanitation, or water in areas where families have been resettled, for example. To identify the extent of the gender engagement and type of analysis needed, to determine the kind and scope of gender-specific expertise needed and associated resource, to identify target groups to be involved, and the major constraints of the project. For example, the barriers against meaningful representation and active participation of women, language, male-dominated spaces, other identity factors that result in marginalization like ethnicity, disability, caste, etc. Also, you need to be aware of managing feedback process and community expectations, and designing appropriate strategies for achieving meaningful participation of women in the process. During the data collection stage, you have to collect data from project-affected areas depending on the potential gender impacts of the project. In order to do this, you need to prepare questions for in-depth interviews, structured and unstructured, and focus group discussions to reveal gender roles and relationships that can cause gender-specific impacts of the project. The data must be collected in consultation with women, indigenous people, ethnic groups, women's organizations, and other community-based organizations. It is important to get disaggregated data on gender to uncover women-specific concerns, to forecast possible impacts, and to develop potential strategies that can mitigate such adverse impacts. During the impact assessment itself, The criteria for evaluating the significance of gender impacts and their effects should be set in advance based on national and international regulatory frameworks. As a good practice in gender impact assessment, it is better to use established procedures or guidelines or relevant criteria which are comparable. Referring to a clear set of guidelines and protocols enables understanding the impact of a project or activities on women, girls, disadvantaged groups, and on the communities in general, and could help frame sound mitigation measures to recommend. It will also help to compare with other cases in other parts of the world. The recommendation chapter of the assessment should include risk mitigation measures targeting gender impacts of mining projects. It should also establish schemes and procedures for this purpose. A plan for operation or execution of the recommended mitigation plan should be in place, including assigning responsibility and time completion. This plan can include active dissemination of the results of the assessment, administrative claims, advocacy campaigns, and criminal or civil legal actions. Legal precautionary measures in regional and/or international human rights protection systems should be considered too. Such a plan must include women-specific indicators, specific redress mechanisms, and specific human rights protection actions. Advocacy, lobby, and communication campaigns must be also tailored on women and girls. A timely implementation of a gender mitigation plan will reduce agitation and conflicts, improve acceptance, help build rapport between authorities, companies, and local communities, and reduce regulatory roadblocks. The timeline must be realistic and reliable. Finally, during the monitoring stage, some of the key issues to be considered include informing the affected communities, and women specifically, on the assessment result and discuss your findings with them. Monitoring whether implementation of recommendations have been considered and/or implemented. Monitoring gender participation through specific indicators, establishing communication channels with women interviewed as a part of the assessment. And checking the effectiveness of gender-responsive measures in reducing risk and enhancing benefits of the project for women, either by authorities or companies. Integrating gender into other legal mechanisms and processes. Legal mechanisms and processes are tools to obtain reparation or mitigation of adverse impacts, and they must be available, effective, and accessible for all victims, particularly for women and girls. The first step is to provide strong gender focus in resettlement policies and in their implementation. This will require greater involvement of women and their groups in all stages of the planning and implementation processes. In addition to this, any concern related to women's rights and gender equality need to be identified, confronted, and tackled effectively. All victims of human rights violation and abuses have the right to an effective remedy and reparation. This right lies at the very core of international human rights law. It is based on the legal obligation of states to respect and protect human rights against violations, but the state and its agent, and from abuses by non-state actors like mining companies. Remedies need to take into account the unequal gendered power relations that govern the context of corporate abuses. In particular, women often face gender-specific violence, stigma, reprisals, and job insecurity for reporting business-related abuses. The multiple and/or intersecting forms of discrimination experienced by women from marginalized groups should also be taken into account. All justice systems, both formal and quasi-judicial systems, should be secure, affordable, and physically accessible to women. All components of the system should adhere to international standards of competence, efficiency, independence, and impartiality, and provide in a timely fashion appropriate and effective remedies. Those remedies must be enforced and lead to sustainable gender-sensitive dispute resolution for all women. They should also be contextualized, dynamic, participatory, open to innovative practical measures, gender-sensitive, and take account of the increasing demands for justice by women. Restitution, a key aspect of reparation, is intended to restore the victim to the original situation that they were in before the violation took place. But if this involves restoring a situation that entrenches discrimination and disadvantage, a more transformative approach is required. Reparations should aspire, to the extent possible, to subvert instead of reinforce pre-existing patterns of cross-cutting structural subordination, gender hierarchies, systematic marginalization, and structural inequalities. In order to develop effective remedies, states need to review the high cost of utilizing formal remedies and judicial process, ensure accessibility of remedies in remote areas of the countries, such as rural areas, ensure that the burden of proof is not disproportionately shouldered by claimants seeking a remedy, establish courts and other quasi-judicial or other bodies across the state in urban, rural, and remote areas, and ensure that they adequate maintenance and funding. Any state must also remove obstacles to women's access to justice and effective remedies. Such a clarification will be consistent with the jurisprudence of the Committee on the Elimination of Discrimination Against Women, which established that under the Convention, the obligation of a state's party requiring them to establish legal protection of the rights of women on an equal basis with men and to ensure through competent national tribunals and other public institutions the effective protection of women against any act of discrimination and to take all appropriate measures to eliminate discriminations against women by any person, organization, or enterprise also extend to acts of national corporations operating extraterritorially. Thanks you all for listening. We hope you enjoy the rest of the course.